Mr. Schra, are you able to hear me okay?
I am, Your Honor. Good morning. Joel Straw on behalf of Mr. Jaraneski, who's seated with me here in the Zoom room.
Thank you. All right, Mr. Brewer, are you able to hear me okay?
I am.
Okay, we'll go on the record in Jaraneski versus Brewer, case number 2419758. The record should reflect that all parties are connected by Zoom video. Mr. Schra is present on behalf of Ms. Jaraneski. This is set for a hearing today. Back on December 4th, the court issued an ex parte order regarding custody and parenting time. Mr. Brewer's filed an objection to that order. So this is set for a hearing on that today. Mr. Brewer, can you tell me what your objection is to that order, please?
Well, I object you suspended my parenting time, and I want to object to that. I don't know, there's quite a bit here going on. Ms. Jaraneski has a PPO against me. I seen her at Walmart, if you remember, and she gave me our son when the PPO was in order, and then filed a violation of PPO. We came in front of you. I admitted to it, I was found guilty. The only thing the violation was text to her regarding our son, who was in our custody, in my custody, excuse me. There was no court order in effect when he went into my custody. And then somehow she slipped through the custody hearing we had a few days later, and this custody hearing went in effect. And I immediately filed papers to change custody and visitation. We came to court multiple times. She never brought up in court to you, to nobody, to say, hey, you need to give him back. I've never been through this, Your Honor. I didn't, I was waiting for her to say I want him back. And then she did file papers saying that that I was in violation of my parenting order. I came to court. We were in front of the magistrate, or another judge, Your Honor, and I never had a chance to speak. He opened it up with, do you want to go to mediation or to court? And they said court, and he set a court date, and it was over. I had no time to talk, to say anything at that referee hearing is what it was, Your Honor.
Yeah, I'm familiar. I watched the video of that, so I saw what happened.
Yeah, I guess I was on meth, Your Honor, because I just cannot believe that she hired a lawyer. I can't believe that she wants to fight me over my 4-year-old. The 4-year-old that I've raised, that's been with me every day. Whether, we go to my shop every day of his life. He goes to my shop with me. She worked. And if she didn't work, she went to my shop with me. And now all of a sudden she wants to split up and take my son from me. I just, I understand that there is an order in effect now that I have to follow, which is every other weekend. I understand that. And I'm working on, I filed papers to change that. So I do understand that, Your Honor. But I'm not going to keep my son. It's hurting my 4-year-old son is who's being hurt by not seeing his father.
Okay. All right, so the concern I have, and I put it in the order, is that if you have parenting time, that we're going to end up in the same situation where you're not returning the child based on what happened before.
Right. But I would never do that, Your Honor. I've been warned. You're warning me. I understand that. I understand that I have to follow that order until that order is changed. I thought that when that order was put in effect, Your Honor, and I filed papers to modify that order, I thought I read in that paperwork that if it was a new order, it didn't apply. Like the order was brand new. I was under the understanding that it didn't apply, and like I said, she never asked for our son back. I mean, she, just don't know. Okay. I'm just, all I know is I will follow the order every other weekend, and that this is killing me and it's hurting my son. I know my son is hurting from this.
All right. Thank you. Mr. Schra.
Thank you, Judge. I appreciate the fact that you reviewed the referee hearing, Your Honor, and I think that in doing so, you probably find that Mr. Brewer's statements today are disingenuous with this court. I mean, I had the distinct impression that he knew that there was an order, he knew that he was in violation, and he knew that he wasn't going to have to face the music until February when it came to returning the child to his son. I mean, he was sneering to the court. He was, he loved the fact that the date was several months out from when we were last before the referee. So his suggestion today that he's going to follow the order and it was just a mistake that he had made in the past, I think is without merit. In reviewing your order, it looks like it's your expectation that we'll have an evidentiary hearing before the referee in February. And at that point, the referee can make a recommendation as to what's in the best interest of the party's 4-year-old son. So I would ask that the court essentially allow us to have that hearing in February and allow the referee to make a recommendation and see where we go from there. The only other thing I'd mention as kind of an aside is that Mr. Brewer did file his objection in a timely fashion. Unfortunately, he didn't serve it on me as counsel of record. So my calendar was open and I was able to attend today's hearing, but I wasn't aware of the objection until sometime after it was filed and my client brought it to my attention. So that's just an important piece for Mr. Brewer to understand if he's going to represent himself in these proceedings, that when he does file anything, it needs to be filed with counsel of record also.
All right, thank you. Mr. Brewer, anything you wanted to say in response to that?
Well, the only thing I had asked the county clerk and she advised me just to mail it to her known address. So from now on, should I just file papers to his office? Is that what he's saying?
Well, yeah, he needs to get a copy of everything that's filed.
Okay. I'll make sure he does.
So, all right. So again, I did review the hearing that was before the referee, and it, you know, I watched it, and it was made very clear, Mr. Brewer, that you know, that you were supposed to return the child, what the current order was that was in place.
Okay.
And my interpretation of that hearing was that you were going to refuse to do that, even though you were aware that.
Excuse me, I'm sorry, Your Honor. I did not mean to interrupt you.
Yeah.
Your Honor, if the referee that day would have told me to return my son, I would have returned him. I understand what you say goes. There is no doubt about that.
Yeah. So, I mean, I watched it, I saw everything that was said, and that's my impression of it. And so that leads me to continue to have the concern that I had at the time that I entered the order, that if you have custody again for parenting time until this is worked out, that we're going to wind up here with another issue, a motion from Mr. Schra, and I'm just not gonna put everybody in that position of creating an issue. So,
okay.
So
All right.
court's order. I've heard your objection. Court's order from December will remain in place. The parties will proceed to hearing as currently scheduled, and we'll go from there.
All right. You have a good day, Your Honor.
All right. Thank you. That's all for this hearing. All parties are free to disconnect at this time.
Thank you, Judge.